Hello, this is Matt on the Moon Family Sedan channel. Ripple is using the Amicus briefs that were filed against them and in favor of the SEC to their benefit in their final brief in the SEC v. Ripple case. Now, technically, this is part 2 of my coverage of this, but and I will link to part 1 below, but don't worry, you don't need to watch that video first. And the reason being is the content within this brief, which really the content of it is 56 pages. There's so many standalone points that I could cover this in any order, and it does not matter. In fact, after the first video, I pointed out, it was I think it was like a 22 minute video, something like that. I pointed out, I was like, wow, don't you see? Like I covered a bunch of stuff to that point. And I said, all that stuff I covered, I could have conveyed that information to you in any order, and it would not have mattered. It would not have detracted whatsoever from the content. So if you really want to check out part 1 first, you can do it. If not, you can just listen to this one first since it's already playing, and then go back to the first video, which I will link in the details section below. Whatever you want is perfectly fine. I'm just telling you so that you don't have to feel like you have to go click on something else. You will be just fine. You're not going to be losing anything. Full context will be here. And also, Ripple addresses the LBRY case, so I'm looking forward to sharing that. And so that's kind of the cool thing, and I mentioned that when I was doing the open for the last video too. Like, there's a lot of stuff that happened after Ripple filed its last brief, which was its motion for summary judgment. After that, we had the conclusion of the LBRY case, and then a whole bunch of amicus briefs were filed. And so stuff been occurring, and Ripple's addressing this. Now, Ripple really goes to great lengths to absolutely shred the SEC in this brief. And this is the final brief in the entire case, by the way. It's almost 2 years this damn thing's been going, so it's nice that we're at the end where this is literally Ripple's final legal brief ever in this case. And what they're doing, though, they're attacking the SEC. So I'm choosing to not cover certain things that I just feel just been beaten to death, like certain aspects of the Howey test. But as it pertains to Ripple shredding the SEC, I am including stuff. So I was admittedly choosy, but this damn thing's 56 pages, so it's got to be. I'm also keeping out, I might as well just mention it now, I'm not going to be covering, other than right this second, the stuff about the individual defendants, Brad Garlinghouse and Chris Larson. It might have been like 10 pages of this damn thing was covering them, and I read through it, and I was like, I honestly didn't find it that interesting. And part of the reason is it's such a BS argument in the first place because the SEC only has jurisdiction in the United States, and as cited in this brief, 95% of Brad Garlinghouse's XRP sales, 95% occurred outside the United States. And the SEC still is trying to act like they have jurisdiction over it. Just as a matter of law, it's over. They do not get to rule over it as a matter of law. I can't imagine that going in favor of the SEC. And then for Chris Larson, he sold 87% of his XRP was sold outside of the United States. There's no jurisdiction whatsoever. So I was like, it's already over. It's like, do I need to go into? And then they listed a whole, just incredible quantity of reasons in addition to that as to why the defendants should not suffer any further from this. But and I agree with that, like it makes sense, but also I want to focus on like more so what's happening with what's going to happen too as a result of this XRP holders specifically, and what happens to Ripple will directly impact what happens to XRP holders, but not as much what happens to as far as Brad Garlinghouse, Chris Larson, whatever happens to them. I mean, look, if XRP holders are screwed, maybe they're screwed too, but I'm just saying that's not where that's not what's going to result in whether or not XRP is allowed to continue to trade in the United States, or allowed to resume trade rather in the United States. So I'm going to pick up right here at the bottom of page 11. It reads as follows. The SEC also argues in substance that the court should ignore its lack of statutory authority because registration of digital assets as securities is supposedly good policy and supposedly not burdensome to potential registrants. In fact, registration itself is currently not possible given various requirements in SEC regulations. Now, folks, I am so glad that Ripple's bringing this up, and I have cited this on the channel at least a handful of times ever since I figured out that this is true. I mean, Brad Garlinghouse was talking about this, and there are a lot of reasons, but one, for example, is you have to be aware of who is buying and selling. Like if it were a stock, you'd have to know who's buying and selling that stock for every single transaction. You can't do that with XRP. It's a public blockchain, and it's just traded freely the world over. You literally can't register XRP. Even if Ripple wanted to try to register XRP before this lawsuit went down, they couldn't. They literally couldn't. It's literally impossible. And here that's one of the things that's most absurd about this. They literally couldn't do it, and the SEC sues them anyway. Well, you should have done this thing that's impossible. You bunch of freaking pricks. My God, this is why we cannot have nice things. Really steams my vegetables. All right, down to the next page. Let's jump on right here. Here we go. But even if Ripple could somehow register XRP, no digital asset exchange in the United States is registered to trade digital asset securities with the SEC, so XRP would be effectively illiquid in the United States, as it has been since the SEC chilled the market by filing this lawsuit. In addition, contrary to the SEC's insistence that products like on-demand liquidity would be unaffected, ODL transactions would need to be conducted on registered exchanges by registered brokers or dealers. Such registration would add time and cost to these transactions, destroying the use case for XRP, which depends upon it being a frictionless and low-cost asset. Yeah, so folks, not only that, it would destroy the XRP use case for the Amici that filed. Think about it. Like, would the XRP ledger make the most sense for Spin the Bits? You know, Spin the Bits just wouldn't comply with this, I imagine. But if they wanted to operate in the United States, would the XRP ledger make the most sense when there's additional registration and costs and time associated with transactions? Because one of the primary benefits, it's a couple of the primary benefits of utilizing the XRP for Spin the Bits, which allows Bitcoin to actually be spent fulfilling Satoshi Nakamoto's vision. Well, you get real-time transactions, and it costs just about zero, to spin the bit, because you're talking about a fraction of a penny of XRP gets eaten up. And then they're a for-profit business, so I don't know exactly what cut they're taking or this or that. But either way, you get the point. You'd be adding unnecessary friction and defeating use case. And then for TapJets, they accept the private jet chartering company. They accept XRP. That's the most popular cryptocurrency. They publicly cited that. Okay, well, if that has to be registered, it's no longer going to be the cheapest. It's no longer going to be the quickest. You're destroying the use case for XRP because reasons. It doesn't make any sense. And again, you still can't even register it, so set that aside. All right. Anyway, let's go to the next part. Let's go to page 14 here. Here we go. Okay. The SEC relies in substantial part on the supposed views of secondary market purchasers to argue that defendants' XRP transactions involved an investment contract with Ripple, and it further contends that XRP remains an investment contract with Ripple when traded in the secondary market. But XRP is fungible. The SEC offers no way that a secondary market purchaser of XRP could distinguish between units of XRP that the SEC concedes do not satisfy all the elements of the Howey test due to the absence of any investment of money, and those it contends do. That unworkable outcome is a clear indication that the SEC is misapplying the Howey test. And I briefly mentioned this in the last video, but given that XRP literally is fungible, you're gonna tell me there's some XRP that's just always an investment contract, and then other XRP that is not. And if so, there's some sort of way to track this realistically. You can't know if somebody sends you XRP. You don't know it's past. I mean, look. You can look at the history of the blockchain, but you don't know what that means. You can see a bounce from address to address. You won't just suddenly know what those addresses are, because just like Bitcoin, the XRP blockchain is pseudo-anonymous. Yes, you can do some forensic accounting to kind of figure stuff out. I don't deny that. Of course that's true. But you're not just going to know that. There's private information that people aren't just going to tell you, even if you try to figure that stuff out. If you're a regulatory agency or the law, okay, fine. Then maybe people will be forced to tell you certain things. I'm just saying. Realistically, there's no way to do what would need to be done here. It's complete garbage ideas from the SEC, as you come to grow and expect. Oh, now to the Hinman stuff. It was only cited once, but the Hinman emails, part of one of them was actually cited in this thing. Now, the only bad news is I don't know what the hell was cited, and if you're looking at your screen, you already know why. It's because it's redacted. Now, this is not Ripple's fault. Ripple is not allowed to share the Hinman emails and of the Ethereum free related to the Ethereum free pass speech or any of the drafts of the speech. They're not allowed to, which is why, since they referenced it here, this is a redacted public version of this brief. But once the judge rules on this, we may very well end up seeing what's in those emails. But until then, I don't know. All I know is that there's something damning enough in those Hinman emails that Ripple's attorneys realized they could use it as ammo in this lawsuit. That should tell you something right there. And so I'll just read to you the little bit I can, which is right here. It's not in the Hinman email itself, but Ripple's attorneys wrote, the SEC itself knows this theory is legally irrelevant. And then it goes to the redacted portion, which is 4 lines. And you can see it says SEC lit emails. And then Ripple's attorneys write, yet it does not acknowledge that well-established point. And so again, no idea what that says, but still, the fact that it's even in there kind of makes the point, because look, Brad Garlinghouse cited that whatever is in these emails, he said it would shock us. And I don't think he'd just say that. I think there's something truly damning. I don't know exactly what it is, but again, the fact that they're using this here to try and save their own asses, I mean, even that is telling, in my humble opinion, which is the right word to say the word opinion. No, y'all say it weird. It's opinion. Opinion. All right, now down to page 26. Opinion. Starting right here. The common enterprise element requires control by the promoter. Check this out. So look, this shows how far the SEC has strayed from relevant case law in its BS arguments. So check this out. You'll see as we go through this, the Ripple just tears them to shreds because they're citing case law that isn't relevant in the Second Circuit. Ripple calls them out for it. It's just a beautiful thing. I love seeing this here. And they think that they can get away. And think about this too. If you're the SEC and you're arguing case law that's not relevant to the circuit you're in, how weak is your argument if that's what you're resorting to because you don't have anything else? Come on. Judge Torres has to see this as back. Yeah, come on. Right? Anyway, it reads as follows. Howie makes clear that the promoters must engage... I'm sorry, no, not engage. The promoters must manage, control, and operate the enterprise. Once again, because the SEC cannot and does not point to any particular enterprise, it cannot and does not show the defendants managed, controlled, and operated any such enterprise. The SEC again builds a straw man, arguing the promoter need not control the entire market for an asset with monopolistic, all-controlling behavior. But that is not defendant's argument. Defendant's argument is that the SEC cannot show that defendants managed, controlled, and operated any common enterprise as Howie requires. Further, the SEC bases its arguments on a single 55-year-old case from the 10th Circuit treating the entire domestic beaver industry as a common enterprise. But the 10th Circuit does not require any showing of commonality, whether horizontal or vertical. So 10th Circuit authority does not establish the applicable test in the Second Circuit. The SEC's reliance on a case applying so divergent a rule only underscores how far it has strayed from controlling law. And so, again, why do you think the SEC is arguing stuff that they must know isn't actually relevant to the case? Like, I don't think they're stupid. I just think they're really bad people. Because like with what they're arguing, I understand if they get their way, like they are destroying people's lives. So I think they're absolutely horrendous people. You know, how do you're arguing about beavers, damn it? Like, what? Of course you are. You're the SEC. Yeah, you're talking about beavers now. Because reasons, wouldn't they ever let's just talk about beavers all day? Because that makes a bunch of freaking sense. Let's go down to page 29 here. Freaking beavers. All right. Here we go. Starting right here. And because XRP is fungible, The SEC cannot sensibly argue that some units of XRP are investment contracts, but others are not. And I was talking about that, but just kind of setting it up so that this flows properly. And then they write, the recent LBRY decision is not to the contrary. There, the court, addressing only Howey's third element, held that a mere possibility that, quote, some unknown number of purchasers may have acquired LBC in part for consumptive purposes, end quote, was insufficient to say categorically that the token was never sold as an investment contract. So let's pause right there. What was stated in that quote, and this is a key part of it, they stated here that some unknown number of purchasers may have acquired LBC. That's the LBRY credit token for consumptive purposes. It's like, again, may have required. That was what was stated in the LBRY case. And as I'm sure most of you, if not all of you, are aware at this point, LBRY did lose against the SEC. And then Ripple's attorneys continue and they write, here, in contrast, there is non-speculative evidence of an enormous number of XRP purchases for use. More than $10 billion worth of XRP that has been used for ODL transactions. Thus, for billions of the units that the SEC claims were sold as investment contracts, the SEC is undisputedly wrong. The SEC challenges the $10 billion figure on the grounds, $10 billion figure on the grounds that it includes sales made after the SEC filed its complaint, but it cannot dispute the fundamental point, which is, unlike every other digital asset case the SEC has brought, there is undisputed evidence here that billions of units were sold for use and not as investment. So, folks, that's why I want to be clear that I'm pointing out those key points there. And that is different than the LBRY case. It's not speculation as to whether or not XRP was purchased for utility purposes, having nothing to do with price. It is a certainty beyond the shadow of a doubt. And also, they noted here that out of the multiple prongs of the Howey test, only the third element was considered in the LBRY case because LBRY's attorneys, which is regretful at this point given that LBRY lost, LBRY's attorneys made the mistake of conceding the other prongs of the Howey test, so the only one that was considered by the judge to come to a conclusion was that third one. And so that's what's being addressed right here, which would be, of course, investment with the expectation of profits, but specifically on the efforts of others. That's the part that matters, on the efforts of others. So I'm glad that Ripple pointed this key difference out in the LBRY case. There are a lot of ways that the LBRY case and the Ripple case are markedly different. And one of the most important ones actually beyond that, even just setting aside the content, is that it's in a different circuit. So different case law applies. So even that alone, and by the way, the case law is in favor. It's better if the case law that applies to the Second Circuit rather than the First Circuit, which is where LBRY was. So from what I've seen anyway. So I'll take that. Now down to page 34, which reads as follows, and this is more on LBRY. Nor can the SEC save its case by pointing to LBRY. Setting aside all that was uncontested in LBRY, the promoter there expressly confirmed that the, quote, long-term value proposition of LBRY, end quote, was, quote, dependent on our team, end quote. In this case, to the contrary, the SEC admits that XRP prices were not dependent on Ripple. Quote, the fair market value of a unit of XRP could increase while Ripple reduces its XRP-related business efforts, end quote. Well, isn't that telling? And that's true. And I don't remember I highlighted it in this paper, but on at least one occasion they noted that Ripple could end up doing well as a business while XRP does not do well. And the inverse is true. XRP could end up, and XRP holders end up doing very well. People speculate on it, and Ripple's business could fall apart. Both are true. It's just they're not tied together. It couldn't be more obvious. Then there's also, here we go. So now I got to jump down to page 53, and this is where I'm hopping over a whole bunch of stuff having to do with the individual defendants, but I cited why at the outset of this video. I just don't think that it's necessary to go into any greater detail. Maybe it's just me. I don't know. I didn't find the rest of it sufficiently interesting. And then once you make the point that, again, they don't have jurisdiction here, how could Judge Torres rule any other than for the small percentage where they did sell in the United States? Okay, fine, but it's not going to be that consequent. What really matters is what the potential penalties for Ripple and, more importantly, to XRP holders, specifically if XRP is categorized as anything. What's it going to be categorized as by the judge? Is it going to be declared to be a non-security? Because the asset itself needs to be declared something, like a non-security, so that it can, life can proceed. Things can go on here. All right, so now we're jumping in page 53. There's this little section titled, "The SEC's Amici do not support its case." And I absolutely love this. Oh, I love this so much. So there were 17 amicus briefs filed. Some people say 15 were in favor of Ripple. At a minimum, it's 13. 2 you might be able to argue were neutral, but even the ones that were neutral, it was in favor of XRP holders. So I'm just like, okay, you could say 15. It's fair. That's fine. And then there were 2 that were filed for the SEC against Ripple. And Ripple ends up using those briefs, which are attacking them. Ripple uses those briefs to its benefit. What sorcery is this? I absolutely love this. Check this out. I kid you not, folks. Check this out. Reads as follows. To Amici, New Sports Economy Institute, which is NSEI for short, and Accredify, so that's the second one, Accredify, submitted proposed briefs in support of the SEC. Neither brief supports the SEC's case. In fact, both support granting defendants a motion for summary judgment and denying the SEC's motion. So again, they're noting it right here at the top. Yes, so they submitted proposed briefs in support of the SEC, but they end up supporting Ripple. And by the way, I will notice this as well. As far as Accredify goes, they filed an application to file the brief, and there was the brief itself, the amicus brief, attached as an exhibit. But then when it came time, after the Accredify received approval to submit that thing, they never actually filed it. So I don't think the judge will, I don't even know if she can, but I don't think the judge will consider that. Presumably she actually read the thing when the application was filed. But I don't think that's going to be part of the case here. But Ripple still, they highlighted anyway. There is a possibility that the judge could just accept it. I haven't seen it, unless I actually missed something that big. I don't think that the judge ever ended up saying a word about it. It was just past the deadline, so I think she just was like, I'm not going to address it. As far as I can tell, that now she reserves the right, of course, to speak upon it or issue anything, tomorrow if she wants. But there's been nothing to this point so far as I know. Anyway, Ripple's attorneys continue. First, NSEI raises a policy argument to suggest that cryptocurrencies should be regulated by the SEC in order to promote investor protection. It does not identify any protections or other benefits that registration would confer on purchasers of digital assets. That is because there are none. I gotta tell you, when I read that the first time, I was laughing. I was absolutely laughing. Because again, the SEC's like, hey, this is all about consumer investor protection, right? You gotta be able to register to protect the investors. But then the SEC never explains what that is. So Ripple's like, yeah, so how the registration of that happen? How is it that it protects the investors? Yes, how is that so? And then they straight out right here, the SEC never explains how it protects investors. How are there any protections? And then that is because there are none. Just very, for some reason, when I read it, it just struck me in that way. I was just like, damn straight, bitch. Absolutely. And then they write the following. As other amici explain, registration would only impose significant burdens on digital asset holders and increase the cost of transactions. Moreover, in making the policy argument, NSEI makes clear that the SEC cannot prevail on existing law. As NSEI expressly admits, quote, cryptocurrencies are, for the most part, not cash flow generating assets. Thus, people cannot invest in them. They can just speculate on them, end quote. So pause right there, just in case it's not clear. This amicus brief, supposed to favor the SEC, just crapped on one of the arguments the SEC is making. The first prong of the Howey test is what? An investment of money. Here, this amicus brief, and allegedly in favor of the SEC, says that people can't invest. They're literally saying you can't do part 1 of the Howey test. You cannot invest. It is not an investment. Don't you love this stuff? That they only got 2 amicus briefs in favor out of the 17. One of them never actually filed. The Credify didn't file. And then the other one right here, they're saying that that XRP can't satisfy the first prong of the Howey test. And I don't even think they know they did that. I don't even think they know they did. I absolutely love this. Anyway, Ripple's attorneys continue. That is one of the many reasons why XRP purchasers could not reasonably have expected profits from defendants, defeating Howey's third element. A speculative motive, quote, on the part of the purchaser or seller does not evidence the existence of an investment contract within the meaning of the Securities Act, end quote. Instead, the Supreme Court has defined an expectation of profits in terms of a residual claim on an entity's assets and earnings. It is undisputed that XRP holders had no such claim on Ripple's assets or cash flows, as NSEI concedes when it observes that no such cash flows could be associated with XRP. So there you go. NSEI, you went and you, and by the way, you owe the SEC money. Isn't that funny? You lost a case against the SEC, and now we're at the point where you're about to find out how much money you owe, and you just happen to write this amicus brief in favor of the SEC. Except for you kind of botched it, didn't you? Oh, my God. Anyway, then Ripple's attorneys continue, and they write, second, a Credify. Oh, a Credify. So this is the one that, got approval to file the amicus brief and then never filed the amicus brief. Second, a Credify argues that Ripple's fair notice defense should fail, but its argument only proves that the law in this area is hopelessly ambiguous. For example, it discusses at length the concept of decentralization, arguing on the basis of the Hinman speech that, if an asset's ownership is decentralized, it should not be considered a security, and even putting forth its own 4-factor test to delineate the path to decentralization and non-security status. That only underscores why defendant and other market participants lacked fair notice. The SEC has never offered clear guidance on when a digital asset is sufficiently decentralized to no longer constitute a security and, based on its positions in this litigation, appears to have abandoned the concept of decentralization entirely. So what else to think about this? So this was why it helps Ripple. Ripple's attorneys are ninjas, man. Do you see what they're doing here? So again, the Accredify guy, the attorney that wrote that, he said that Ripple's fair notice defense is bogus, it fails, and then he goes on to explain why there's not clarity in the space, which means that Ripple obviously didn't have fair notice. Oh, but what the hell kind of circus is this? I love this. I absolutely love this. Oh my God. Anyway, Ripple's attorneys continue. Can you believe these have there's 2 filed in favor of the SEC and they're botched. I just love this. I love this. Okay, anyway. That the SEC's own amicus thinks the legal regime that applies is different from the one the SEC is applying here only shows that the SEC has created hopeless confusion in this area that deprives Ripple and other market participants of fair notice. You can't make this stuff up, folks. Can't make this stuff up. Oh, man. And then it says, in any event, this is right here, in any event, even if Accredify's test of whether one or few centralized entities control 50% or more of the total issuance of the asset were governing the law, that would mean XRP has attained non-security status because Ripple today owns less than 50% of XRP, notwithstanding Accredify's incorrect statements to the contrary, which are supported by no citations to any evidence. Yeah, and I ripped out the shreds when I covered that amicus brief. That Accredify guy, he didn't know what he was talking about. He literally just, and I don't say that just to insult him, like he literally didn't know what he's talking about. Ripple holds less than 50% of XRP, and he was saying that something should be a non-security if it's less than 50, if the holdings are less than 50%, and he says that XRP is a security. I'm just like, what? Completely ridiculous. So that was it. That's the final legal brief. That's it. It's over. Let me know what you think in the comment section below, but that's it. That's a wrap. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.